Welcome to the afternoon constitutional and our theme song titled Compensating for Something. My name is Joe Thomas, and we are brought to you by the Government Accountability and Oversight Group, govoversight.org. We're the ones with the Klieg lamps shining in them in the dark corners of places where people, let's just say, the law students and the creative writing students have gotten together and they can get very, very creative in how they write what they believe to be loopholes around the laws that govern whether or not you can know what they're doing in your name. Now, we've got a very interesting show today because perhaps one of the most existential issues facing the United States right now is the issue of big tech. And whenever anyone vilifies an entire group just out of hat, I step back. But there's a couple of things, having been in the broadcast industry for 37 plus years, I know that my liabilities for things that go out over the airwaves of my program is unquestionable. I am the publisher of that broadcast. I am the owner of that content. And unfortunately, it seems that somewhere along the line, in an effort to get the technology companies that were going to profit from your advertisement, you're advertising the data that they collect from you while you surf online through their internet portals, they managed to convince the government, much like the pharmaceutical industry convinced the government, that they shouldn't really be held accountable for their broadcasts and their efforts and those sorts of things. And as we await our guests to join us through our Zoom conference, I'm going to give you a little background on where we think we fall with Section 230, which is the section that they convinced the federal government to give them a hall pass. Hang on one sec. Sorry, we were just checking in with Professor Dickinson, who's going to take us inside of the Supreme Court's ruling. So Section 230, the abstract of Section 230 is much like the pharmaceutical industry was given a hall pass on liability for inoculants in the 80s. And they've actually violated that agreement plenty of times, but they don't seem to be held account to it. The technology companies at the burgeoning early days, the prehistoric days of the internet, they asked the government for permission to be excused from those nasty little liability costs that might befall a traditional publisher like a newspaper or a magazine or a radio broadcast or a television broadcast. So they said, we would like to not be held accountable for the things that are on our TV network. I say this to you knowing full well that we come to you via YouTube and that is a Google property. And the Supreme Court case in question was Gonzales versus Google, where the Supreme Court ruled unanimously in favor of Google. And as our next guest is going to tell us, that may have been the right decision, as much as someone might look for the day where an entity like a Google could be held to account for the things that they publish in the same way, say, Time Magazine or any of those folks would be. Professor Greg Dickinson is joining us now from St. Thomas University. Professor Dickinson, thank you so much for joining us today. How are you doing? And again, thanks for taking a little time out on this issue of Gonzales versus Google.
Yeah, so thanks for having me. And it's an exciting day to be an internet law professor. We've been waiting for months now for these decisions to come down. They're a little bit of a letdown, honestly. But as you say, getting it right is more important than making all the law professors out there happy with an interesting new opinion.
And your contention is that they got it right, that they did the right thing with this decision. As much as I would like to see Google or Twitter or Facebook held to account for the things they publish, you write that that's not really what this case was about, correct?
Yeah, it almost was. And so when you have a case like this, you have two hurdles if you're a plaintiff. Because in this context, you're suing somebody who isn't the direct bad guy.
Mm-hmm.
You're suing Twitter, you're suing Facebook, you're suing Google, you're suing somebody like that about a terrorist attack. And so there's one obvious bad guy, that's the terrorist, and you could definitely sue the terrorist or ISIS or whoever. But when you try to sue somebody like Google, you're looking to impose what's called secondary liability or vicarious liability, somebody other than the direct wrongdoer. And there's a few hurdles to that. One is Section 230, which is what's been getting all the press recently.
Mm-hmm.
But when you're bringing a claim like that, there's kind of old-fashioned hurdles too. You have to show that they bear some responsibility for it. And the context determines exactly what you have to show. But here the argument was that Google and Facebook, Twitter, all of these platforms had aided and abetted an act of international terrorism. And entirely apart from Section 230, that's a pretty hard thing to show, that somebody other than the terrorist should be treated just like the terrorist. And
Mm-hmm.
so you had this hurdle even before the 230 issue came up.
So when the case came about, so this is about a family whose son was lost in a terrorist attack, and he was suing, saying that the ISIS videos, that came up in some feeds, were what promoted the act of terrorism, and therefore Google could be held accountable. Am I understanding the kind of nuts and bolts of this case, Professor Dickinson?
Yeah, that's exactly right. They were suing under the Anti-Terrorism Act, which is targeted at providing U.S. citizens with an avenue of relief against terrorists. So if you or your family member gets hurt in an act of international terrorism, you have an avenue in the U.S. federal court system to sue them. And then there's another provision that says in some cases you can sue also for aiding and abetting. So not just the direct terrorist, but anyone who aids and abets them.
Mm-hmm.
And the theory here for that was that the platforms provided kind of a means of communication, that they provided, or that those means of communication included recommendation algorithms that, as everybody's seen, they're really good at figuring out what you like looking at.
Mm-hmm.
And so if you like looking at terrorism videos, then you're going to get more and more of that. And then the last allegation or argument for aiding and abetting liability was that in some contexts, the platforms knew that ISIS was using them and allowed them to persist in doing that. And the argument was that this constituted aiding and abetting an act of terrorism under the Anti-Terrorism Act. That was the plaintiff's theory, at least.
So how does Section 230 come into play here? Because a lot of folks were saying, this will be it, and then they were disappointed. But I'd rather get a case that actually puts a platform that's monetizing its content, much in the way I compare it to Reader's Digest used to, because it was all user contributed content that then they sold advertising in. So this case really wasn't specifically about 230. They just brought that in because I guess Google used it as one of the premises for why they shouldn't have been held liable.
Yeah, and if you're an internet defendant, anytime you get sued for just about anything that relates to your users, you're going to want to raise a Section 230 defense. Section 230 is almost like a backstop that says, if assuming the plaintiff can plead a claim against you, assuming the plaintiff actually has a plausible claim against you, even then, you might still be immune from liability if Section 230 applies. And broadly speaking, it's a law that says online platforms aren't liable for the content that their users post. And so, as I was saying before, you have kind of two hurdles to suing somebody like this. You have, first of all, it's just hard to sue people that aren't the direct wrongdoer in general. But even if you do have a claim, and defamation was a traditional context where this could happen, even if you do have a claim against somebody who's kind of transmitting the message rather than the actual original bad guy, well, then the online platforms, unlike traditional companies, well, they have this extra defense under Section 230. And as you were kind of hinting at, a lot of people wonder whether, given how mature the internet is now and how all-encompassing they are, I wonder if they need special protection anymore. Others are wondering that too. And so this was going to be the big case. Or these two, there's actually a pair of cases. These were going to be the big cases. And maybe the Supreme Court was going to rein in Section 230 just a bit and say, it's a useful law. It's important that we not have Twitter liable for everything that anybody ever says, but maybe it's been taken too far. Everybody thought these might be the cases for that, and it turned out not. That's not what the court did with this.
And it was Clarence Thomas who actually wrote the majority opinion. I guess it was a unanimous opinion in that, and basically said that this case, they did not make the case that Google substantively provided ISIS with the opportunity to recruit through their platform. I had an interesting defense of 230 brought to me, and it was that if I send an email to you and it says, I'm mad at you and I'm going to come to your house and break all your windows, Google isn't liable for reading that email if I send it through Gmail. I hadn't really thought about it that way, but I guess that would be akin to going after the U.S. mail for something sent through just a traditional letter, isn't it?
Yeah, so you get these are delightful hypotheticals for law professors to think through, but they actually happen sometimes too, and that's the kind of thing that we're talking about here. You see this with potential tort liability for firearm manufacturers.
Yeah.
You see it, some claims against, largely not successful, but claims against, for instance, fast food companies, for people with weight trouble, or even like violent video game makers, if something happens after that. And you can see a relationship, it's not impossible to see the relationship there, but usually the law says no, we're not going to recognize claims if really it's somebody else's action involved here. But sometimes that's not the case. Sometimes we do recognize secondary liability, and you kind of hinted at this earlier. What I and other people would like to see is a case that really squarely presents that to the court. A case where you have a true strong claim for secondary liability, and then Section 230 needs to be interpreted by the Supreme Court to see if, because the secondary liability claim is strong, whether Section 230 nonetheless provides a defense.
Well, and here comes, this program is called the Constitutional, and what I would prefer than waiting for the Supreme Court to rule on this is the U.S. House and Senate to sit down and say, as you said earlier, Professor, gee, you think these guys really need this anymore? And look at it as, in terms of what they are doing. We compared Mark Zuckerberg to William Randolph Hearst from 100 years prior, with magazines and newspapers in every major city in America, and wielding great influence with the editorial power there. But I would feel better with a legislative fix. As a law professor, what do you think about that?
Yeah, I'm with you 100%. If you read this statute, Section 230 of the Communications Decency Act, it's very obviously designed for a different internet. It's designed for one that was just taking off. It talks a lot about kind of the new educational opportunities that the
Mhm.
internet was going to create, about the importance of preserving this kind of fledgling means of communication. But that's not what we have anymore, and it doesn't mean there aren't valid concerns there. There's wonderful things you can do on the internet, and if you subject those entities to too much liability, well, it all goes away. But it's enough of a different internet now that it would be nice to see a modern Congress come together and see what they think about regulating the internet of the 2020s instead of the internet of
Mm.
1996.
Well, for those who are wondering, this is not a dye job. This is actually hard-earned gray hair, and I've been around long enough to remember this internet site called Napster. And as a internet law professor, you've probably heard of Napster. And I remember there was a fellow, was vice president for a little while, ran around with his wife wanting to shut down Napster, put labels on CDs. But the hue and cry was, we have to do something about Napster, and we want Congress to act immediately, 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 shut them down, ban them. And I believe 230 came up then as well in Napster's defense. But it was this little art house startup technology company called Macintosh, along with this little player they had called an iPod. And then Sony saying, hey, we could sell singles. We used to do that. And Napster became an irrelevancy. I know the site still exists for file sharing, but the marketplace did a pretty good job of fixing Napster's wagon in the piracy world. Professor, what kind of free market solutions could there be to fixing the issue with this online content?
Yeah, so that's what you always hope for. You hope that the market can take care of it, because that's so much smoother than having an extra bit of red tape that every company that operates has to look through and figure out how to not violate. And so when you can do that, that's the very best way. And so the context where I see this coming up most often presently is in the online censorship debates.
Mm-hmm.
Who's allowed to say what on the internet.
Mm-hmm.
And ideally, what you'd have is you'd have some companies spring up like Parler was. Parler was in the news a couple of years back,
Right.
saying, we're a family-friendly site, or else we're a kind of a free speech embracing site.
Mm-hmm.
And then you kind of pick what you want to do. If you kind of are very worried about being offended or encountering offensive material, you go over here. If you very much have some strong views to express that you're worried it won't get out there on a more traditional platform, you go
Mm-hmm.
somewhere else.
Yeah.
And I could very much see the market finding a solution there.
Yeah.
Uh,
I hear something. There's this company called Twitter that might be, working in that world. But unfortunately, there are few and far between. But I've told people, in the past, and we've already had one episode of this program taken down because of content, because we talked about medicine, and don't even start. But Professor, the idea that free speech becomes almost a slogan, becomes a marketing tool, that you can come here and we're not going to censor you, is important. But there are also ways, and I pushed back on Elon Musk a little bit, not physically. I wish I knew him, but against his context that Twitter was now the town square, because I said it's not. It's a company, and you have to go and do something to get into it. It's not the town square, which is just an open place where I could walk down the street unencumbered by a police officer and speak my piece to a neighbor. It's not quite the town square, and I think I certainly understand his marketing model to say it is, but we have to be very cautious, don't we, Professor, that we give these internet sites too much gravity in our world. There are other ways to communicate our messages with people without having to go through Facebook Messenger or Twitter or those kind of things. Correct?
Yeah, the courts are having a really hard time figuring out how to deal with social media companies and kind of free expression. Because on the one hand, you can see they're incredibly important.
Mm.
They're kind of like we had mass media, the rise of mass media over the last century, really displaced a lot of traditional methods of communication, and internet mass media is doing the same thing. And so you don't want to
This
understate their
program, yeah.
importance. We're having a great chat now, and we couldn't have had it, a few decades ago.
Yeah, NBC
Uh,
wasn't putting this show on the air, so
so a lot is happening there, and they are tremendously important. But you have this fight now, this dispute. Well, are they so important? Are they so economically powerful, or so kind of overwhelmingly important that, for instance, as Florida and Texas have done, do we need laws that say, here's what you have to publish? You have to publish regardless of content or something like that. And that's really a direction that courts have historically been hesitant to go, because after all, Twitter's a private company,
mhm.
and so you have this tension between they've gotten so powerful that they're almost are market dominant, some of these platforms, and yet they're still private companies, and they have their own interest in kind of maintaining an appearance that suits their business
Mm.
model.
Well, and I'd like to see the phrase "public facing" used more. I know it sounds a little politically correct, but I have free speech, but I am in a public facing position, so I have extra responsibilities given the public facing of that. The same is true for a retail establishment that welcomes in the public and things like that. It could, as a law professor, could we nuance something like that that could allow for the public interaction through places like Facebook or Instagram or whatnot, while still maintaining the fact that they are private companies, just public-facing ones?
Yeah, that's the direction that Justice Thomas kind of hinted a little bit in his. He had a concurrence in actually denial, the court deciding not to hear a case several months back, maybe last term, where he said, we have things like the Americans with Disabilities Act, we have things like the Civil Rights Act that say certain private companies, because they hold themselves out to the public as serving everyone, they can't discriminate against people on the basis of race or ability, for instance. Maybe he really was equivocal, but he said maybe we ought to start thinking about whether online platforms fall into that same realm. You don't want your phone company saying you're not allowed to make phone calls anymore because the
Hmm.
things you say
Right.
it doesn't agree with. But it's a tough question whether the platforms are really quite that powerful yet. They have some good arguments that they're not. But that's the sort of debate that's going on right now. And I could see, maybe not this term, although
Mhm.
maybe the court going in that direction and say, some restrictions on their own expression are permissible just because the public so heavily relies on this technology.
What is, and you talk about the public reliance on the technology for communications. I remember also, I'm old enough to remember the beginnings of the RICO Act laws in New York, and Mayor Giuliani and well, actually, I guess it was U.S. Attorney for the Southern District of New York, Giuliani, trying to get RICO statutes. So if they found one mob low-level enforcer, they could charge everybody with the conspiracy. But one of the adjuncts to that was they were trying to figure out wiretap laws, and that the wiretap laws as they were instituted, you had to give a specific address and explain why you wanted the wiretap under the Fourth Amendment, but you could only wiretap that address. And this was the beginning of the advent of cell phones, and they were trying to grapple with that. And I bring this up, Professor, because I think there's an entanglement with our investigative and surveillance systems in all of these social media companies. Does that complicate matters that they do have, and they do permit access to the FBI and to the CIA, regardless of what TikTok does with the Chinese Communist Party?
So it varies a bit from company to company. Some companies, like Apple, has built a bit of a reputation for this. Actually, will try to compete on this ground, and they'll say, our system is super secure. We don't preserve any more data than we have to. It stays encrypted, and we can't unencrypt it. So there is some variation between companies, but because it's such an attractive target to law enforcement. And by that, I mean, it's just so valuable. If somebody
Sure.
does something wrong, there's a good chance they said something about it. And if you could only get that
Yeah.
data, maybe you could find them. So it's a fight between consumers who value their privacy and the government who naturally wants to catch the bad guys. And the real the place where this is really in contest right now is where there's just huge stores of data, and the government would love to look at it without any more detail than absolutely necessary. You mentioned
Hmm.
you used to need exactly the address or the phone number or something like that. Now are some very limited contexts where you might scoop in more data really than about one particular person. It might be several people in a geographic range or something.
Yeah.
Um, and so that's where the dispute is about. It's
Mm.
just such a treasure trove of data. If you're going about your job looking for the bad guys, that it's even if you're pretty principled and want to abide
Mhm.
by the law, you also want to get your guy, and so it's hard.
Well, and I guess the issue is who's that guy and what does he get to be able to use to defend himself? I had this debate regarding security cameras in the downtown area of our flagship city with the police chief, and I said, really, I don't have a problem with the existence of cameras. They're going to be there. It becomes an admissibility issue, and I'm only the grandkid of a lawyer, so please, if I say something that's not necessarily legal, don't hold it against me. Does that have to be something that Congress should be looking at as well? In ways to make sure that we have admissibility protections for the things we do online, because we mentioned town square. So if a police car sees me standing next to somebody that they know is a bad guy, is they're watching him for drug dealing, and they take me in because I was standing next to him and I just happened to be waiting for the crosswalk. The admissibility of that frozen moment needs to be something that my lawyer needs to be able to look into, don't they, Professor Dickinson? Dickinson?
This, yeah, so this tends to be an area where the most work gets done, not in fresh legislation, although you could have it, but in kind of interpretation and application of the constitutional rights against an unreasonable seizure and kind of
Mhm.
case law protecting against the use of evidence improperly acquired against you, the Supreme Court applying those existing precedents in new contexts. And even though the Supreme Court is majority conservative now, it's been quite protective in many cases of process,
Mhm.
making sure things get done in the right way. And so I don't, I'm not aware, at least, I'm not a criminal law guy. And so
No, no, I understand that.
I hate to
Um,
say that what I don't know doesn't exist, but I'm not aware of movement in that direction.
Well, and conservatives should be, watching for process, because process should be how we protect people's rights. And and this one is really an abstract to it, but I think it's important as it relates to the internet. And it's bugged me for some time. Ever since Mark Zuckerberg was named Man of the Year several years ago, probably more years ago than I'd like to remember. But I was reading the Time magazine piece about him being named Person of the Year, and it struck me that somewhere during the article, the reporter, the author, reports they were in this wonderful disassociative meeting room, and they're sitting around a foosball table, and then the head of the FBI poked his head in and said, "Hey, Mark, we'll be down in our corner office." And the reporter never followed up on that story saying, "Hey, that was the what." And I wonder because we have this little thing called the Third Amendment that says we can't have government soldiers stationed in our homes in times of peace without our permission. And every lawyer I've spoken to said, when you click I accept on the terms of agreement on most of these apps and these softwares, buried down in there is some agreement that they will share or could share your information with other parties. Is that something that I could make the case? And it just bothers me that I don't know if that's necessarily informed consent if you're given really no other option but to accept to use the software. And then the software company says, and by the way, we are going to share some of this information with third parties if we see fit. Professor, as an internet law person, is there a case to be said for informed consent in those user agreements?
So yeah, this gets under my skin as a consumer. I guess it gets under my skin. As a law professor, I know that the
Good.
law is
I'm not the only one. I thought I was crazy.
So those things are generally enforceable. You don't read it, but you click OK. Generally speaking, as long as you know that you're entering into an agreement and you kind of just decided not to read it, it is enforceable. And the theory behind it is, you could have decided not to do it, but you valued the product enough. You said, whatever you say in there, I'm willing to abide by that,
Right.
even if it's pretty lousy for you. And so the bad news is that those things are generally enforceable. But I guess the good news is that if the government and a company were kind of closely enough allied together, and that would start to look bad, and that could cause problems. But as far as the agreements go, they are enforceable. Even though you talk to law professors, you talk to lawyers, nobody reads them. It's just you
Right.
wouldn't have enough time in your life to read all of those things.
Well, and there aren't options to use this piece of software without that codicil. I mean, if there were two pieces of software that produce video and one says we could share your information and one says we won't, maybe I'd choose the other one. And here's I grew up in Queens, New York, and I have an unusual haircut. There was a guy before that was very popular in the art of the deal. And here's my deal. Here's my offer for the internet companies. You keep Section 230 and you give us our privacy back under the Third Amendment, and take away some of those agreements that open-handedly say that we can share information with third parties if we see fit. Is that a deal that I could strike? I probably need a bigger platform than that. But if Google comes to me and says, that video you did on YouTube, we want to talk to you about that, and I offer them that deal, does that seem like a reasonable deal, Professor Dickinson?
So I could imagine something like this happening. The platforms they don't want major Section 230 reform, but they could accept minor reform. And at the same time, Congress has been for years now, unfortunately, debating what to do about online privacy, whether to enact a kind of a universal 50-state federal privacy law, or whether to leave it to the states, or what exactly to do. And I could imagine some sort of a backroom deal where the platforms and some representatives aligned with their interests, who kind of see the world the same way, decide to structure 230 or restructure it in one way in exchange for a certain structuring of any federal data privacy law. So you wouldn't see it out in the open. I don't think, but I could imagine those are two issues that are both important enough to the companies and to the nation that you could see some horse trading on those two issues.
Well, I appreciate it. Professor Dickinson from St. Thomas University, a law professor, internet law specifically. What do I owe you for the class time? I feel like I should pay for these classroom hours, but I appreciate it. I hope your students are this interested in this. I know sometimes I feel like I'm teetering on being just slightly more interesting than watching paint dry. But these are essential to me issues that are kind of itching and burning and peeling at everything we do. So I appreciate you taking some time out with us and getting into it.
It's a real pleasure. I do the job because I love talking about this stuff. So anytime.
Well, I appreciate it, sir. You have a great afternoon.
All right. You too. Bye now.
And and thank you for watching today. And we appreciate your time, and thank you for being on with us. And we hope to see you again very soon. And we'll be back here tomorrow afternoon at 3 for all of us here at the Afternoon Constitutional. I don't know why the camera froze, but it's probably Google doing it to me, so I had to switch to our backup camera. So long, and thanks for all the fish.